少有5分。
So, well, it's been more than 5 minutes. So let's continue with the meeting. So members and the administration. May 26th at the meeting then, we raised some questions then, and the administration on some proposals gave us a written reply. So maybe the administration can, on your report, can you brief us on them, whether they're in the paper or not? DD. Yes, on the issues raised last time, and we have provided you with some additional information. First is on our requirements that will be discussed with ALBA. And we are actually preparing that paper. In 1 or 2 days it will be finished, and you should be able to get the paper by then for your scrutiny. And on the whole, in the related contract with ALBA, we will require it to be within 3 days, providing removal service. That would be a contractual obligation on their part. And the committee also asked us to explain, under the new licensing system, the requirements for recyclers and how they can obtain the licenses concerned. Just then we discussed about it, and we had quite a thorough discussion, and we briefed you on that is what the applicants need to show and the requirements for them. After the meeting today, we will very quickly prepare paper on that to you. But let me supplement. In the future, for the licensing conditions, of course, I know the sector is very worried about what the conditions are and how we set the conditions. Besides giving you the paper on the conditions, we will try to be very open with the sector and brief them, tell them clearly on what the conditions are. At the last meeting, members also asked us to submit, that is on the Environmental Advisory Council's in relation to the regulation and commencement notices, the views of the council mainly. But we will provide you with the information on that, on the views of the council. On the whole, the Environmental Advisory Council supports our work and our plans ahead. Thank you. So now, members, any follow-up questions? Ted Hui, the third round. Okay, 5 minutes for now, because scrutinizing bills is different from other subjects or meetings, so we hope that there can be adequate discussion. At the last meeting, I suggested that is session 927 of the ordinance about labeling of product. I did say this to the administration, whether you make reference to the compulsory labeling for electrical appliances to help the consumers make distinctions. Why? Because I think the government would admit that you need to let the labels be seen, conspicuous to the consumers. And you must let the consumers know that levy has been paid for the product, and whether the levy has been transferred to the equipment. The consumers need to know, that they have been charged or not. That's why they have to pay a high cost. They need to know, because not every equipment needs to be labeled. And also, on the compulsory labeling scheme, when the purpose of the scheme, besides giving consumers the choice, one of the intention is to enhance the understanding of energy efficiency. So in dealing with environmental protection ordinances, shouldn't we show on the label to the public that there is such a legislation in place so that the public could be more motivated to recycle products? And thirdly, for some precautionary approaches, because the label is not on every product, because people who buy online would not have their products labeled, neither would there be labels on parallel goods. Or some sellers will try to dodge the labeling requirement. So you need to give the public an awareness that having a label could be a sort of a protection for them. So what do you think, Didi? Maybe I'll ask my colleague to supplement more later on as for the use of labeling and requirements for labeling. But on the whole, I very much agree with Mr. Hui. That is, we hope that consumers can be made aware that in terms of a recycling fee, the equipment's concerned, have paid the fees or not. And in the bill, in the future, the sellers must list in the receipts to let the consumers know that whether the recycling levy has been paid or not. As for how the labeling can be clearer, made clearer to consumers, and how to strike a balance, I'll ask my colleague to supplement. Mr. Lai, the difference between recycling labels and energy efficiency labels is that this label is issued by the government, whereas the energy efficiency labels is subject to a different arrangement. The labeling approach was actually a key subject during the consultation. The importers mentioned to us that they may not do it the same way as in putting on energy efficiency labels. Their concern was that often the manufacturing lines are not in Hong Kong, so sometimes if you have to stick a label onto it, that would add to the cost. But in drafting the legislation, we prepare for some flexibility. Say, for example, we've mentioned that it's not mandatory to put the label, so that reflects an outcome of a discussion with the sector. But having heard Mr. Ted Hui's views, I think if we can let the sellers know that if they want to put on a label, they can actually put on the label as part of a guideline or introduction of a product to the consumers, and that would be beneficial. So I think we will tackle this issue through administrative means. What do you mean by administrative means, Mr. Lai? I think our view is that we will, at the sales level, within the regulatory framework, because the sellers are also required to provide removal service and offer receipts. So at the sales level, the salesperson, for example, in dealing with the customer, we expect this salesperson to provide relevant information to the consumer. So whether the staff training of sellers can include introducing the label to and the recycling levy to the customers, I think that can be done. And it's not just about labeling, but also, for example, arrangement for removal office, taking away of old equipment, all that can be made part of staff training. Okay, follow up here. The labels to the consumers in the future. What is the use of the labels to the consumers? And whether the labels exist or not, whether they're stuck on the product or not. What's the use to the consumers? Can you explain that? I think for the consumers, the main purpose of the labels is to let them know that the equipment concerned has paid the levy, so that the consumers know. So yeah, the fact, and of course you'll also be concerned for the removal service, whether consumers must show a label before the removal service can be obtained. But we won't make such a requirement. That is, if the label is obtained by the consumer, if the consumer's lost it, or for some reasons he cannot produce the label again, he can still ask for the consumer removal service. The most important is that the consumers are aware that the equipment has paid the levy, and also that in terms of public education, the consumers are better educated, and they know that there is this provision of removal service, and of the upstream, the manufacturers can expect to pay a fee. But in the future, if the consumer is not buying a new equipment, You just want to dispose of old equipment, dispose of an old equipment for removal service, or if it's one day that the consumer wants to dispose of just an old equipment because it doesn't need it anymore. So having a label or not, would it incur fees at all in terms of disposing of the equipment appropriately? Well, the removal service is really not linked to the labels. We are not talking about removal service. I'm talking about if removal means you're getting a new equipment, okay, and you ask the seller to take away the old equipment for you. But I'm talking about someone, who doesn't need the equipment. He just wants to get rid of it. So having a label or not doesn't make any difference. If it's outside of the removal service, that is, if someone, as I said, some deputations said that for products that are not governed by removal service under the new scheme, we will provide services in various districts in CGS to offer service to help people get rid of their equipment, unwanted waste. So I think the collected waste can be recycled. So the consumers themselves, if they haven't bought any new equipment, of course they won't be given any removal service, but they can use existing channels to get rid of their waste. So it's not because they don't have the labels that they will have to pay more fees. So consumers may feel that, well, it would not be fair to me because under the scheme I paid the fee, the levy in getting the equipment, and later on the recyclers, because I don't have the label, then I have to be charged more for disposing of the equipment. So would that happen?
No, that won't happen. All right, the next one. Mr. Gary Chen. Thank you, Chairman. I would like to ask, in relation to ALBA, when they are dealing with the e-waste, they cannot recycle 100% of the e-waste. So my impression that is 25% of the e-waste will not be processed or reprocessed. So what happens to these 25%? Now, Deputy Director, the requirement is 20%. So if they collect some e-waste, they reprocess it, dismantle them. Say 20% of them cannot be dismantled. Maybe less than 20% sometimes, 15%. So that may involve, say, some parts with chemical parts, or plastics which cannot be recycled for further use. So these are the materials which cannot be recycled. So we're talking about 20% instead of 25%, is that right? So how is the process like? Say, if I collect a computer mainframe, and how will they handle the materials or the components inside? Are they going to dismantle them, break them down, or what? Deputy Director, for the REE, different electrical appliances come with different reprocessing procedures. Overall, there will be a dismantling, and then there will be the materials to be sorted and recycled for further use. Say, for example, for PCBs, if PCBs have to be further broken down, then they may involve extra chemical sort of breakdown process. So the PCBs will not be further broken down. That was also mentioned in the last meeting. What about the nuts and bolts and iron dismantled as a result? Will they be used locally, or will they be exported out of Hong Kong? Mr. Lai. For the ALBA, there are 4 dismantling lines which will handle different types of WEEs. The first step is detoxification, and depending on the toxic elements involved or the hazardous materials involved, then they will be treated initially, then they will then be handled at the chemical treatment plant for downstream treatment. For non-toxic elements, it will be broken down and then sorted out, the plastics and iron and so on, and they will then be recycled for further use. Now, if there are downstream manufacturers for these products, and they can take on these materials, and this will be arranged by ELBA. I have a more macro question here. Deputy Director said that in the beginning, ELBA could handle 30,000 tons of e-waste per year. In the market, 70,000 tons are produced every year. Now, for those which are not being handled under the latest law, these should not be dumped in the landfill. So how are you going to deal with them? After the discussion just now, we found that there is only one company, ELBA, which can get a license. For the small operators, probably they won't get a license. So what will happen to these 40,000 tons of e-waste? It cannot be dumped in the landfills. Mr. Gary Chan, I don't follow your question. Maybe some of the operators cannot meet with the legal requirements. But then some of the deputations said that they will be very active in getting a license. Some are confident of getting a license. Some are disappointed, and they are not hopeful that they will get a license. So I think so. These are the situation is not like what you said. So anyway, DD. Wow. I understand Mr. Gary Chan's question of the 70,000 tons of materials that they have to be dealt with. Some operators will apply for a license. We cannot be too pessimistic to say that none of them can get a license. Our licensing requirements are reasonable, and we hope that the existing operators can get a license as long as they meet with the requirements, and they can take part in the recycling of the REE in the future. Now, say in the future, if some of the operators cannot get a license, and maybe some others don't want to participate for some reason. So does ELBA have enough capacity to handle the REEs? Now, as I said, there is 50,000 tons of e-waste. So under normal circumstances, ELBA can have a capacity of 30,000 tons. Say, if there is a great need or demand in the market, ELBA can deal with more volume by way of, say, working overtime or extending their service hours. So can I ask a question here? I believe that the administration has looked at the present situation of the operations, existing operations, and how their premises are like. A realistic question here. On brownfield sites, there are indeed recycling operations now. From the speeches of the deputations today, I learned that some operators are very concerned about the continuous operation on these brownfield sites. Some of them are on short-term tenancies. They are worried whether they can meet with the licensing requirements. Another class of operators is the small-sized operators. I believe the principal ordinance has provided exemptions for these small operators. So there are two classes of operators. How well do you understand their operations? Especially for operations on brownfield sites, do you expect that they have difficulties in getting a license, or is it that they don't have to be excessively worried as long as they can meet with certain requirements and they can get a license? Thank you. You are very concerned about the land use, whether it complies with the relevant regulations, because we do have a regulation on the land use. Say, for example, if this is a piece of agricultural land, and if there are operations on this plot, then they may not be able to meet with the regulation. And for some other cases, maybe they have to make an application for rezoning to the TPB or apply for a planning permit in order to meet with the planned land use. So there are different scenarios. we believe that for some recycling yards, well, we do have some assessment on the present situation. Some are worried that they will definitely not get a license. But then from information on hand, it's not the case that no one of them can get a license. There are not many operators working on agricultural land. Some of them are working on industrial land, and some of them have to make a rezoning application with the TPB, Town Planning Board. So it's difficult for us to make a generalization or make an accurate estimate of the number of compliant operators. So that's why our colleagues have been liaising with them all the time, asking for information from them so that we can better assess the situation. Now, because different land uses come with different procedures required, for each individual case, we have to look at them one by one to see whether they comply with the town planning ordinance. So it's very difficult for us to give you an accurate figure on how many of them will meet with the requirements. Mr. Ted Hui, you referred to one point about the recycling labels and the fact that the recycling label has been issued will be written on the receipt. Now, the consumer will only get the receipt when they have bought the electrical appliance. But when they are choosing or selecting the products, they will not be able to know whether there is a recycling label. Now, you talk about strengthening public education. I agree with that, and I won't repeat that. Now, when it comes to the REE, well, these products are very durable. They can last, say, 5 years, 10 years, or even 20 years. Now, if the label stays on the product and consumers will not tear it off, say if 10 years later they want to replace the product, maybe they will have forgotten that there is this surface removal plan for them. They would just discard the product, the used product, in the garbage, in the refuse collection station downstairs, and they would forget about the removal service plan. I don't think the label is directly related to the removal service plan. Say if a product has already come with the payment of a recycling label, even if they don't have the label in the future, they can still ask the seller to provide the removal service. And as I said, whether there is a time limit for the consumers to raise this removal service request. When a consumer buys a new product, he can ask for a removal service. And our suggestion is that they should make the request within 3 days. There's been a suggestion that 3 days are too long. Maybe we should say start counting the 3 days from the date of placing the order. No, I'm not talking about this. I'm talking about, say, 10 years later. Will the consumer still remember that the levy fee has already been paid and there is a removal service available? Or will the label affect the behavior of the consumer? They have forgotten about the removal service and then they would discard the product in the refuse collection point. Deputy Director, well, under the regulations, the levy fee will be paid at the upstream side. So if 10 years later, as time passes, will it be the case that the effect of the label will be lost? I don't think it has to do with the label. I think we should achieve our objective rather by continuous public education. Now, say some years later, if a consumer, maybe he doesn't need the removal service because he's not buying a new product. He just wants to discard an existing product without buying a new one. And he said that this has nothing to do with the label. He can still discard or dispose the product through services provided by the community. Say if the consumer needs a removal service, will the seller say charge him extra if the consumer has lost the label? No, that's not the core of my question. No, that's not my question. Whether he's lost a label and he has to pay something extra. Well, my question is whether because the label is lost, then he can't remember that there is this removal service, and he will discard the product casually. Well, my point is whether the product comes with the label, the consumer can still use the removal service. So can the Deputy Director answer both of our questions? If I understand Mr. Hui correctly, his question is, maybe the consumer buys a product, say 10 years later, whether that the label is still there or not there. Well, if there is a label, then the consumer can remember that a levy has already been paid. Then he can, with the label, then he can more easily remember that there is a removal service. Well, the answer is that beyond a certain period, the consumer cannot raise his removal service request. But as I said, apart from the removal service plan, there are recyclers in the community who can provide a service. Say, for example, the community green station scheme. They are providing the removal service or disposal service. So anyway, you refer to whether you would affix the label onto the product, and before you made a decision, you have consulted extensively the trade and you consider their operational difficulties. Now, label, is directly related to the consumers, and it will affect whether the consumers will use the removal service, and that is really the core spirit or the gist of the regulation. So, do you think we should move an amendment to the regulation to the effect that sailors and manufacturers should affix the label on the product itself, at the expense of creating some technical difficulties to the suppliers and manufacturers? I think the Deputy Director has already answered that question. Anyway, please answer. We understand that the consumers should be made well aware that a levy has been paid, and then they should know about this plan. But labeling is not the only avenue which can make them aware of this. And when we talk to the trade about this label, they do find that it's quite difficult. They are not looking at the compliance cost, or rather the whole supply chain, how say from the manufacturer to the wholesale and retail process. So we are now proposing that the label should not be mandated to be affixed onto the product, but still we are asking the sellers to make sure that the consumers know that the levy has been paid, including say distributing the label to the consumers, and also the label may have to be given to the consumers together with the invoice in the future. So there are different avenues to let the consumers know that a levy has been paid for a certain product. As to how we should more effectively make consumers aware that how the levy has worked, then we can consider more. Well, I would like to let the subcommittee know that I will move my some CSAs on my own. Mr. Kerry Chan, I am again on the quantity or the volume of hand capacity or handling. Now, if needed, Alba can step up its efforts and can handle all the 50,000 tons of REE. Say if the Alba can't do it, it can't recruit enough staff. For the remaining 10,000 tons of REE, how will it handle them? The Deputy Director said that it can be disposed of at the Community Green Stations scheme. Can that scheme handle that substantial amount? I think it will be, say, a short-term measure. I don't believe that they would set up a permanent storage space for these e-waste. The members' concern is that maybe under the licensing system, will a lot of the recyclers be gone? And as a result, Hong Kong cannot handle the volume of e-waste produced. Deputy Director, we fully understand the members' concerned, and we are duty-bound to ensure that after the legislation takes effect, the REE will be handled, all the REE will be handled properly. So that's why we are setting up this facility, facility. Maybe I would like to add here, back then the electrical was concerned that after the PRS for e-waste has been implemented, will that be a scenario where all the e-waste could not be handled when there is a licensing system? And so it's against this background that we are building this facility. This is something that we would definitely handle. We would make sure that there is proper disposal of e-waste in the future. I can't remember exactly how many community green stations are there and what is the handling capacity of each station. I visited the one in Sha Tin. Well, it was just the size of this meeting room, and they are also handling other waste as well, like plastic waste, etc. So if the e-waste is temporarily stored in the community, then the great nuisance will be caused to the community. And it will also have an impact on the other types of waste. So how many CGS do we have in Hong Kong? Deputy Director for Alba. Well, it would depend on the CGS for storing the e-waste for them on a temporary basis.
In fact, Alba has its own plant. It also has a collection center, 5 regional centers, and also 8 smaller satellite collection centers. So in terms of collection and storage, they can meet our requirement. In other words, no REE will be placed in the community. Is it correct? There are 2 scenarios. If Alba cannot cope with the quantity of REE, will the REE be put in the community green stations? The answer is none. But will there be REE collected by CGS? In fact, there will be, because CGSs are now collecting REE. And the REE will be then sent to the operators for processing. Members, last time, the administration briefed us on the framework of the ordinance and also the regulation, and members have voiced their concerns. As for studying the regulation, I believe members will raise questions accordingly, and the text of the regulation will address members' concerns. Therefore, I think it is time to go into clause-by-clause study of the regulation. I'm rather easy on the way of discussing the provisions. So members will be given a lot of leeway. In respect of the notice, certain provisions will commence on the 21st of April, and another two provisions will commence on the 16th of June. As for the remaining provisions, how will they be dealt with? Now, with regard to the principal ordinance, we are to amend 2 existing provisions. Number 1, the PERO, and also the concerning the PERO and also the WDO. The commencement will be made accordingly. Concerning the PERO, we have to commence certain provisions to enable the Secretary to have the power to enact the regulation, the REE regulation. And as for other provisions, when the preparatory work is ready, then there will be further commencement notices in respect of each and every measure. As for the WDO, it is about licensing and permits. In our clause-by-clause study, in the clause-by-clause study, we had already explained that the licensing, the application for licensing will start on the 19th of June. In the principal ordinance, there are exemptions. In the commencement notice, there is no provision in respect of exemptions. Can you explain that as well? Chairman, with regard to exemption, that is Section 16 of WDO. The provisions will commence together with the licensing regime. So at present, there is no need to commence those provisions. Mr. Chenakan. At our last meeting, the administration, or rather, the Secretariat has given us a paper, and the paper asked the administration to provide supplementary information. And the administration said that it doesn't have the information ready. I prefer to have such information first before we go into clause-by-clause study of the bill. Members have made a number of comments on the licensing conditions and also the commencement date. If we do not have the information, it will not be appropriate for us to go into clause-by-clause study of the bill. As I said, in respect of studying the regulation, there will be new questions arising from the study. As for asking for further information in writing, they are related, but they are not covered by the regulation. The information, if you have got the information, or if you have got the information paper, then you can raise your questions. It doesn't mean that nothing can be said, even if we have started, after we have started the clause-by-clause study of the bill. Well, in fact, we are about to end our meeting. We don't have much time left. But I just say that if we look at the bill, the regulation clause by clause, there may be new questions arising. Since there is still some time left, I will ask the officials to study the regulation clause by clause. Concerning the commencement notice, members has already done the clause-by-clause study of the commencement notice. I will now ask my colleague to take you through the regulation. Chairman, Mr. Lai, concerning the first clause of our EE, that's about the commencement date. Commencement will be done accordingly, and there will be separate notices in the commencement notice. Clause 2 is in respect of the interpretation. I will not go over the interpretation definitions one by one. Hold it. Concerning the interpretation, any questions? This is about the removal and also the returns and things like that. Any questions? If not, then Mr. Lai, please go on. Clauses 3 to 7 deals with Part 2, Division 1. That's about the registration for suppliers. Members may refer to Section 4 or Clause 4. There are two types of registration. Mr. Lai, concerning interpretation, we have gone through it very quickly. Can you explain to us that some of the definitions are present in the principal ordinance so that we don't need to worry about them? Some are specific definitions or specific terms in the regulation. So can you point out the specific terms which are just which are only present in this regulation but not in the principal ordinance? I think we need to go over it more carefully. So under Clause 2, do you want to highlight anything or do you want to draw our attention to some of the definitions? Well, I have nothing special about this. In respect of definition, they are not different from the principal ordinance. They are cross-references. They just specify they are just cross-references to certain sections. Mr. Chenakan, I have a question in respect of interpretation. What do you mean by discrepancy list? Chairman, the discrepancy list, it is in relation to, we will further explain it under audit report. When a registered supplier provides a return every quarter, then every year there must be some auditing work done. And in the auditing process, it is found that there are discrepancies in the returns. Then the returns can be amended according to the discrepancy list. And if there is overpayment or underpayment, there will be arrangement to do the refund or payments. Mr. Chen may refer to Section 20 of the draft regulation in respect of the discrepancy list. Now, Mr. Lai, please go on. We've just now come to Division 1 of Part 2. I would like to draw members' attention to Section 4. The supplier can request for an ordinary registration or a short-term registration. The short-term registration is to deal with the situation in which the supplier may have been in operation for a shorter period of time and the levy may be smaller. The levy amount will be smaller if the supplier is registered as an ordinary supplier, then that may not be appropriate, and therefore we have a short-term registration arrangement for these small suppliers. If we are to deal with a short-term registration under 5.2, there is a provision showing a specific requirement, and that is no more than 30 days, operation for no more than 30 days, and the amount is not exceeding $20,000. Under 5.2b, if an applicant has made several short-term registration and the levy in total exceeds more than $20,000, then we will have to consider the recent short-term registration or registrations. This is to avoid abuse. The registration process is rather straightforward and simple. We consider the information furnished, and then we then give the approval. If further information is required, we do have the authority. If there is any refusal, notices can be issued. That's for registration. Mr. Chen Hakan, I just want to know why should there be a short-term registration? Is it raised by the trade? In fact, in the principal ordinance, there was such a discussion. It was about the exhibitions. Now, during the last Bills Committee, there was a discussion on the understanding of short-term exhibitions, in particular overseas exhibitions, or overseas participants in respect of in exhibitions, and the short-term overseas participants in exhibitions still have to pay the registration fee, and that therefore the fee, the ordinary registration may not be reasonable. There are not too many these short-term registration in the electrical appliances trade. As far as exhibition is concerned, there are not too many of them require short-term registration. Why you need to define intended short-term registration or latest short-term registration, so on and so forth. Now, it is a bit complicated. If there is a supplier who comes forward to apply for a short-term registration, then we will consider information furnished and consider whether they will operate for more than 30 days, and also whether they will that will give rise to a liability of to paying a recycling levy not more than $20,000. Now, the short-term registration will last for no more than 30 days. Within a year, some may apply for short-term registration in January, and then another short-term registration in another month. As a result, the levy may have been accumulated to a greater amount, and therefore we require therefore we have the 5(2)(b). As I've explained, in the electrical and electronic appliances trade, there are not too many such short-term registrations. If suppliers are making many short-term registrations, that may not be the case. So you are dealing with exhibitions and sales. Is it common for exhibitions and sales? Or do they have exhibitions only and sales will be dealt with on other occasions? According to understanding, the TDC does have electrical appliances exhibitions, and they display new models. If you want to place an order, you will have to do it somewhere else. The exhibit may just be prototypes. There are not too many occasions in which the products are sold in the exhibition. If that's the case, then why you have the arrangements for recent short-term registration and also intended short-term registration? Well, it doesn't mean that there is no such possibility. They want to catch this situation as well. What's the difference between the recent short-term registration and intended short-term registration? As for recent short-term registration, that was something in the past. But I also have to deal with the short-term registration that is under application. And the total, we have to consider whether the recent plus the intended will exceed $20,000. It is about N+1. N is something that has been completed, and the +1 is the current application. As long as the recent short-term registration and plus the short-term intended registration will not exceed $20,000 as far as the levy is concerned, and then they can get a short-term registration. Otherwise, or exceeding $20,000, they will have to get an ordinary registration. Correct. Section 6. This is about the application process. It's rather straightforward. If we need further information, we have the power to seek that, and then we can approve the application. As for short-term registration, it only lasts for at most 30 days, depending on the actual situation. In subdivision 2, there is only one, or rather, in division 2, there is only one provision. If there is any change of address provided by the applicant, then this is a process for making the change. Address is very important because after a return or report is given, then we need to communicate with the registered supplier, and we need the address. Mr. Chen, I have a question for 6.2. The first cut-off date for an ordinary registration must fall on the 31st of March, 30th of June, 30th of September, or 30th of December, 31st of December. Why you set down these dates? Will that affect the operation of the suppliers or sellers? Well, that is acceptable to the trade. The suppliers will provide the returns on a quarterly basis. We've adopted this approach for plastic bag levy, so this time we adopt the same approach. And the trade does not find any problem with this. And if there is no such date, the suppliers will have different cycles for handing in the returns.
So I think there is this is very common in companies. Division 3, Subdivision 1 is about recycling labels. That is, the registered supplier, when distributing electrical equipment, he needs to provide these labels. It's not directly, it's only partially related to what Mr. Tang Hui was mentioning because it doesn't touch upon the retail level. But here it says that the distributor or the people delivering the equipment to the seller, the label during that shipment process should be there already. You don't have to stick it onto the equipment. You can actually just stick it on the package box. So there's flexibility, and the sector welcomed this change. Tang Hui? I think technically speaking, I think that it's better to stick it on the equipment because making reference to Cap 598 on the energy efficiency label for imports and the original suppliers, the labeling is required. So if at this stage all the labels are there, then you don't need to wait till the distributors do it. And also, in this section, you mentioned that there will be penalties and there could be changes of address, whereas for labeling, there's no penalty involved. So does it mean that you think labeling isn't that important, or you think that the penalty is already included in the principal ordinance? Didi? As explained by my colleague, right now on this section, we don't think there's a need for the supplier to stick the label. There's no need for the suppliers to do that. Bracket 3 here says that the label is not required to be provided by affixing it onto the regulated electrical equipment. So therefore, the penalty is more about our requirement that for the sellers, at the sellers level, the sellers are required to provide a label to consumers, and there are penalties covered in later sections. Okay, the meeting is supposed to end at 12:45, so it's very limited time now for us. So I think let's continue next time with the scrutiny. The date for the next meeting is scheduled for, is set for May 26th, Friday, 8:30 till 10:30. So one meeting is arranged now, and I'll arrange with the Secretariat to see if we need more time to deal with the scrutiny, because 2 hours may not be enough. We'll see the meeting schedules. Again, I'll discuss it with the Secretary. Okay, no AOB, meeting adjourned.
好，唔該晒各位嚇，今日。